Good morning, Ms. Ford.
Good morning, my lord. I appear for the appellants, who are two independent corporate groups, the Autoliv Defendants and the ZF Appellants. Mr. West, KC, appears with Mr. Butler for the respondents, who are the claimants in the proceedings below. This is my appeal against the ruling of the Competition Appeal Tribunal concerning expert evidence. These proceedings are cartel damages claims, which are valued by the claimants at coming up to €1 billion. In defending the proceedings brought against them, the tribunal has directed that the appellants may only share one expert in the field of competition economics between them. They may not each instruct their own expert. In our submission, the tribunal has erred in law in failing to recognise that there are material conflicts of interest between the defendant groups in relation to economic issues, and our submission is that the defendant should be permitted to instruct their own economic expert. In terms of the structure of my submissions, I propose to start by addressing the applicable legal principles. I'll then show the court the relevant passages of the pleaded case. Thirdly, I'll make my submissions on why we say that there are three relevant conflicts of interest arising between the defendant groups in this case. And fourthly, I'll turn to address the tribunal's reasoning in its rulings. Starting with the applicable legal principles, there is a growing body of judicial learning from recent cartel damages claims about economic expert evidence and how it functions in assisting to determine either the existence or the non-existence of an overcharge. And one such judgment is the judgment of the Competition Appeal Tribunal in Royal Mail and DAF, which is in Authorities Bundle 2 behind tab 2. This was a follow-on damages claim based on a commission decision finding a cartel in respect of trucks. And can I ask the court please to start at page 390.
390?
390, yes. There should be a heading, How Regression Models Work.
This
Paragraph
is Royal Mail and DAF.
Royal Mail and DAF, my lord, yes.
I'm looking at Royal Mail and DAF and it doesn't have a page 390, but maybe I'm looking at the wrong case.
My lord, I'm referring to the bundle page numbers. It may
well,
be that it's
I'm
135 in the original. I'm looking at paragraph 328.
Oh, I see. I think I found it now. What was the page number?
In the bundle, it's 390.
It's not.
Ah.
In the electronic bundle, well, in the physical bundle, it says Authorities 390. That is page 89 of the CMC transcript. So, which case do you want?
It's Royal Mail Group and DAF. I'm looking at volume 2 of the Authorities Bundle, tab 2.
Well, I don't have volumes.
No,
Which tab number?
Tab 2, my lord, I apologise.
No, this is...
Tab 1 in the electronic bundle.
Oh, I see. It's tab 1 in the electronic
Page
bundle.
394 of the PDF is 390 bundle.
Page 90.
394 is the page number.
My lords, those behind me suggest that the court was provided with a corrected electronic bundle, and it may be that your lordship's looking at a different version. I do apologise.
Can a corrected electronic bundle be sent? Which paragraph in this decision do you want to go to?
It's starting at 328, so there's a heading, How Regression Models Work.
Okay. Thank you.
And the tribunal there has explained that a regression model is a commonly adopted statistical technique designed to find a conditional correlation between two variables, the dependent variable, which in this case is truck price, and independent or explanatory variables, which in this case are a range of observable factors such as truck costs, strength of demand, the time of year, etc. And it goes on in the following two paragraphs to give a fairly detailed explanation of how the regression model might work. And then at 331, what it explains is the essential purpose of the regression models in this case was to produce an estimate of the effect of the infringement. This is achieved using a so-called dummy variable as one of the explanatory variables in the regression, which takes the value of 1 during the infringement period and 0 at all other times. The coefficient estimate on the infringement dummy variable should measure whether, having controlled for all other variable factors and possible influences on price, truck prices tended to be higher during the infringement period than outside it. So that's the tribunal's summary of how these regression models work. And in our submission, one gets three particular insights from the tribunal's judgment. The first is that while there was broad consensus between the economics experts that this was, in broad terms, the appropriate methodology, the tribunal notes that there was considerable scope for debate and disagreement between the experts about exactly how to specify the model in order to achieve that outcome. And we see that recorded at 332. So the tribunal says there is broad consensus that a multiple regression model is the most effective way to assess the relationship between one economic variable and another. Both experts adopted this methodology. The implementation of this methodology, and in particular the specification of their regression models, involving a very large number of choices, gives rise to the contentious issues on which the experts did not agree and which was the subject of debate in their reports and during their concurrent evidence session. And the tribunal points out these choices that the experts have to make have considerable effects on the estimation coefficients. And if the court reads on, what we see is that the debates are not matters that were specific to this particular case. They arise in respect of what the tribunal describes as a number of common and well-known difficulties with multiple regression estimation. So the first point that I emphasise is that economic analysis of this nature involves making a large number of choices which may well be contentious and which are capable of having considerable effects on the outcome. The second relevant insight concerns the extent to which a model such as this can address questions of causation. And the court will see at paragraph 333 that there was a submission made by the defendants in that case, faced with an economic model which purported to show an overcharge, that regression models do not allow analysts to claim a causal connection. They say there is correlation from which causation may be inferred at most. And the tribunal agrees with that proposition up to a point. It says over the page, it is true to say that the estimated coefficients in a regression model can at best measure only the existence of a statistical relationship or correlation between the dependent and explanatory variables. It cannot in itself say whether that is a causal relationship and that the variation in the explanatory variable actually exerts an influence that causes the observed changes in the dependent variable. But then it then goes on to say, nevertheless, the experts set up their regression models with explanatory variables that are expected to have a causal influence on truck prices. For example, there are sound reasons in economic theory to expect that higher manufacturing costs would exert a positive causal influence on truck prices. And of course, that is ultimately the purpose of the exercise. One seeks to specify the economic model in such a way as to include all factors which might be expected to influence prices. And so there is then a reasonable basis to attempt to draw inferences about whether one particular factor does or does not have a causal impact. And the reason I'm emphasising this is because, as we will see, particularly from the tribunal's second judgment on this issue, that its reasoning as to why there was no need to have separate experts was that all the expert evidence can do is identify the existence of an overcharge. And it's saying one cannot distinguish the causes of that overcharge, and in particular, one cannot distinguish between the circumstances of two defendant groups. And so the tribunal says, well, why do you need two experts in those circumstances? And that, in our submission, is excessively simplistic. In our submission, the whole point of the exercise is that the economic experts seek to formulate their model so as to include the relevant variables with the intention that causal relationships can be explored. And what conclusions can be drawn from that model is then an exercise of judgment for the expert and ultimately for the tribunal. That is the second point we draw from this judgment. And the third...
Is it envisaged that you have, in this case now, you'll have three experts, all with completely different models, taking different variables and doing whatever they think? Is it envisaged the tribunal will then decide between the variables and conduct its own regression model?
My Lord, there will initially be a process of reconciliation as between the experts, an agree-disagree statement, and so it's to be hoped that there'll be a certain amount of common ground. There may well be disagreements, in particular on matters such as whether a particular variable should or shouldn't be included, or what's the best sort of data for the model, but the experts will at least initially engage in their agree-disagree process, so those areas of disagreement can then be brought out. And then in my submission, it is commonplace for the tribunal then to be asked to rule on such disputes as remain concerning what is the appropriate data, what is the best approach. But what we will see, both in this judgment and in another judgment that I propose to show the court, is that there's judicial recognition that there is no right answer to that sort of exercise. It's all a matter of judgment. And so in adjudicating disputes of that nature, the tribunal will essentially be testing the expressed opinions of the expert and deciding which is the best outcome. And the courts have said they consider it's not possible for the tribunal to run its own regression in a perfect way. And I can show, my lord, exactly that.
Sounds pretty obvious to me.
Well, my lord,
Sure,
indeed, we
need
would say so.
authority for that.
We would say so, my lord.
But
The actual passage
what
on-
you want is for the tribunal not merely to adjudicate as between the claimant's expert and the defendant's expert, but also to adjudicate as between rival experts on behalf of the defendants.
My lord, insofar as is necessary. It's certainly a possibility that the defendants may take a different approach, not least because, as these judgments emphasise, it is all a matter of expert judgment, and there may be different perceived ways of approaching things. And there may be differences in the circumstances of the relevant defendants that drive these judgments that are being exercised by the expert.
But how
And
does
so-
that work when there's no contribution notice or no pleaded case as between the two groups of defendants?
Well, my lord, that is a point that the tribunal has raised. It says there's no issue of apportionment as between the defendant groups because there is no contribution notice. In our submission, there's nevertheless a dispute on the face, a pleaded issue on the face of the pleadings, which brings these matters into issue. And that's because the claimants have, as they're fully entitled to do, pleaded an undifferentiated claim for damages on a joint and several liability basis against both sets of independent defendants. And that, in our submission, absolutely unavoidably raises a question as to how those claims and that total damage is to be split as between the defendant groups. We then see...
Sorry, I don't follow that. Why is the opposite not true? If it's a joint and several claim, it unavoidably, if they're successful, and that's of course the big if, but assume they are successful, it results in both sets of defendants being jointly liable for the same sum.
My lord, yes, and of course that's the perspective from the claimant's point of view. But what that means is that matters in issue in these proceedings will necessarily affect questions as between the defendants as to who then pays those amounts. It's true that the formal legal position remains that they are jointly and severally liable for the totality. But in our submission, the commercial reality is that there will have to be some accommodation between them, either by means of negotiation or ultimately by means of contribution proceedings, whereby that sum is then split between them. And the matters that, I will come on to show the court, the matters that the claimant's expert has already traversed in his expert report do go to the relative liability of the defendants in that process. And so in our submission, insofar as there is a conflict of interest which operates on this expert exercise, it cannot be appropriate. The defendants are not permitted to instruct their own expert. But I will show the court.
Just to be clear, Ms. Ford, I would like you to help me understand why what you just said is right as a matter of principle.
Lord, I'm grateful. I'll attempt to do so. I was just extracting the three principles that I say come out of the DAF case.
I mean, just to explore that a little bit further, because my lord's observation might be considered a little bit general, mercurial even. I'm concerned as to the role of an expert. I mean, experts are giving their expertise, so they're not taking sides. They're giving their expertise on behalf of parties to litigation. They're not your spokesperson. They're not your mouthpiece. They're looking at a problem and giving their expertise. Why, if there is no pleaded conflict between the two defendant groups, can't one expert give that expert's expertise and say, this is the way I think, as an expert, the problem should be dealt with? And then later, once the court has determined, CAT has determined the question of liability, maybe you will need separate experts. And that, you see, I think there's a sort of fundamental problem with the idea that everybody's entitled to have a champion in the form of an expert to promote their case as between you and the other side, whichever other side it is. That's not what experts are for. Experts are to give, there is a level of expertise, and the question is, do we need 3 levels of expertise here? Because we happen to have 2 people who were involved in this cartel. If we had 6 people involved in this cartel, would we have 7 experts, all giving different parameters and things that might be conceived as being beneficial to their cartel members? I'm sorry, I'm prejudging the case. Of course, I don't intend to do that, but for the sake of exposition.
My Lord, it's very helpful to hear your Lordship's concerns. I will be relying on a judgment of the Court of Appeal in the Trucks case, which I'm going to come to shortly, which in our submission grapples directly with that point, because it concerned whether or not an individual expert could act for 2 parties that had a conflict of interest. And what the Court of Appeal makes clear in that judgment, in my submission, is that it's no answer to those concerns to assume that the expert will comply with their independent duties to the tribunal. We don't in any way take issue or seek to resist that the expert must act independently and exercise their independent judgment. But what we will see from that judgment is that actually it doesn't resolve the conflict of interest point. And that judgment draws on... I'm sorry.
No, Thomas, well, just to unpick my perhaps mercurial question point, the bit that I'm concerned about, picking up with what my Lord has said, is that since it's clear that the court can and does routinely order a single joint expert to give evidence in a case where there is a manifest conflict between a claimant and a defendant, that is a routine thing that happens in civil justice up and down the land every day, probably exaggerating a little for exposition, but it's absolutely routine. What that indicates to me is that as a matter of principle, the existence of an absolute diametric conflict, you couldn't have a bigger conflict than the conflict between the claimant and the defendant, is not a principle on which it says, therefore you must not have single joint expert between 2 parties with a conflict.
My Lord, it depends on the subject matter of that the expert is being asked to address. So in my submission, it is entirely appropriate for a single joint expert to be appointed in circumstances where the expert is being asked to opine on an area of expertise with which the court requires assistance, but in relation to which essentially there's an established and non-controversial body of information on which the expert is drawing, and essentially the issue is not one which then engages directly the conflicts of interest between the parties. There's no doubt that the conflict is between the claimant and defendant in terms of who can win the case, but the circumstances in which it's appropriate to have that single joint expert are where there is essentially an established body of expertise that expert can reasonably and proportionately assist the court with.
If you haven't got established expertise, how can you have expert evidence in the first place?
My Lord, that's entirely fair, but the circumstances in which a single expert is considered enough are those where it's not normally expected that there will be any relevant divergence, such that the court would not be assisted by having 2 alternative experts identifying the areas of disagreement between them.
I don't understand that. Take the most common example, which is property valuation. It's absolutely routine for claimants and defendants to have radically different ideas as to the value of a property at a particular date in time. And it's very easy to find experts who will opine genuinely, in their opinion, for different figures. But the courts have recognised that actually the best way forward in such cases is to have a single expert giving a single valuation.
My Lord, yes, it may be that that's because the principles on which the expert draws in doing that are relatively well established and uncontroversial. I will be placing reliance on the Court of Appeal judgment, which has taken essentially the opposite position in relation to these issues of expert economic evidence.
So shall we look at trucks? I think it's tab 3 in the bundle, in the judgment of the Chancellor.
My Lord, yes.
Is it paragraph 84 or 94? You told me earlier.
My Lord, it
About that.
starts at paragraph 88 and goes on to 95 and 96. Just before we get to it, may I show the court one further passage from the judgment we were looking at, because it's the one that is then cross-referred to in the Court of Appeal judgment.
Certainly.
My Lord, it's the beginning at paragraph 475 in the judgment we were in.
The judgment we were in. Okay.
It's the DAF judgment.
Yes.
And it's the area where the tribunal is expressing its conclusions on overcharge. And this is the passage that I was referring to, my Lord, when I was saying that the tribunal cannot itself conduct an ideal regression model. And this is the tribunal saying that. So paragraph 475, partway down, it says, nor is it feasible to specify an ideal regression equation based on the various work of the experts that could be relied upon to yield the correct answer to the overcharge question, which would navigate successfully between the rival claim and the conflicting conclusions reached by the experts. There are too many imperfections in the evidence and insoluble practical problems to allow such an approach. And for completeness, we can note that the court isn't here simply referring to specific imperfections in the approach of these particular experts. We can see that from 479, paragraph 479, partway down, where it says several of the imperfections in the experts' regression models do not yield a definitive solution, and we believe that no regression model should. So what the tribunal there is saying is that in doing this exercise, there is no definitive right answer. It's all an exercise of judgment. And that is what is then drawn on by the Court of Appeal in trucks.
But is there a right answer in a property valuation? Actually, not really. It's a question of applying the Red Book surveyor's valuation principles. Two surveyors will undoubtedly get different answers applying those principles in good faith, but it's an expert job which has to be done in order to resolve litigation. Why is this any different from that example or any other expert example where obviously there are two good faith experts who can reach different conclusions, but we don't need in the courts to hear everybody's opinion before deciding a case fairly and justly?
My Lord, in my submission, it is because of the particular nature of the econometric analysis, which involves a series of expert judgments and which the Court of Appeal considers is inherently subjective in nature. That's the way it puts it.
But I mean, the fact that it's inherently subjective seems to me, anyway, at first, without prejudging anything, seems to operate against you. I mean, the fact that it's really subjective just means that you could have any number of opinions, and eventually the court has got to decide. So having two would be better than having three, would be better than having seven, because at least you'd have, no doubt, attempted to get the best experts you could dealing with the problem at hand. I mean, why should the court be faced with 7 experts in a case with 6 defendants?
Well, my Lord, there's certainly a question of proportionality that the tribunal is entitled to take into account, and that has to be weighed up against questions of conflict of interest.
Okay, so you say proportionality is certainly relevant.
What one sees in this case is the tribunal acknowledges that proportionality is not a relevant consideration in a case of this value, and I'll show the tribunal the ruling on that. It's conceded that that's the case. This is, of course, approaching billion-euro claim. And so,
sorry to interrupt, but can I be clear? You seemed, in the answer you gave to my Lord, the Master of Rolls, to accept that a conflict of interest is not determinative. Is that, do you really accept that?
my Lord, I'm grateful for your Lordship's question. No. I recognise...
You say the existence of a conflict of interest is determinative and removes any discretion, regardless of considerations of proportionality.
My Lord, yes, I say that if there is a conflict of interest, that precludes two experts from being instructed. That is something that the tribunal itself accepted. It recognised that it will not be, I think it will not ordinarily be appropriate to insist on a joint expert in circumstances where there is a conflict of interest. In responding to my Lord's question, I was recognising that normally when a tribunal is exercising its power to adjudicate whether or not one is permitted to adduce expert evidence or not, it will be taking into account questions of proportionality. But my submission is that, and of course it didn't find any the way against us in this case, but my submission is, insofar as there is a conflict of interest, that has to determine the outcome.
Well, I think we need to look at both at what the Court of Appeal said and what the tribunal said.
My Lord, yes. So turning first to the Court of Appeal, this was another trucks case, in particular in collective proceedings. It arose out of the same trucks infringement that was in issue in the DAF case, and the issue of law in this case is summarised in paragraph 1 of the judgment of the Chancellor, and he's saying the issue of law in broad terms is whether a single class representative can represent a class in relation to a common issue in circumstances where there is an actual or potential conflict of interest between two groups of class members. Now, the particular conflict of interest that was in issue in this case was between new truck purchasers and used truck purchasers. So it arose because a new truck purchaser might have passed on any overcharge when they sell their truck. And it's in the new truck purchaser's interest to say they have borne the overcharge and they didn't pass it on, and in the used truck purchaser's interest to say that the overcharge was passed on to them, and so they have borne the overcharge, and so there is a conflict of interest between them. Paragraph 88 in this judgment. The Chancellor says, I'm firmly of the view that the conflict between new truck purchasers and used truck purchasers over resale pass-on which the RHA faces can be addressed by the erection of a Chinese wall within the RHA organisation for the purpose of dealing with that issue. This will need to involve a separate team within the RHA acting for each of the two subclasses, instructing different firms of solicitors and counsel and a different expert or experts. The particular issue with experts is then addressed at paragraph 95. And the Court of Appeal says, I consider that the CAT was wrong to accept the suggestion that Mr. Davis, who was the expert economist in this case, could be the expert for both sides of the new used divide. And its reasoning is then in paragraph 96. And what it does is it echoes the points that I've been showing the court from the first instance authorities about the extent to which econometric analysis is an exercise in judgment to which there is no right answer. So it says this approach ignores the fact that any regression analysis and determination will be highly sensitive to the assumptions made and data input. There is an inevitable element of subjectivity both in the selection of the data and these assumptions. Without in any way being critical of or doubting the integrity of Dr. Davis, complete objectivity in expert economic evidence cannot really be achieved. This was a point made by the CAT in Royal Mail in relation to the expert evidence there on overcharge at 475 to 480, which is the passage that I showed the court. Since there is no single objectively ascertainable right answer to the overcharge pass-on issue, and the decision of how to advance an argument on this issue in the proceedings will inevitably involve some strategic considerations, it cannot be sufficient for the divided loyalty which the RHA owes to the two groups of PCMs, proposed class members, to be resolved by a vague promise that the RHA will decide how to act on the basis of advice from Dr. Davis. So,
but is this not confusing expert evidence with factual evidence? I mean, expert evidence, if there cannot be complete objectivity in giving expert evidence, then it's not expert evidence. If you are taking subjective decisions governed by your client's interests, that's not expert evidence. It may be factual evidence, it may be admissible, I don't know, that may be a further discussion, but it's not expert. I mean, you know, I did a lot of competition cases, and the competition world seems to believe that the rules of civil litigation are different, and it's all completely different in magic, because you're dealing with economics rather than law. But actually, what underlies the economics in competition litigation is law, and the rules are the same. And I think we have to be extremely careful about setting up some new legal structure for expert evidence in competition cases. I mean, I'm concerned by that sentence. I mean, I'm not going to try and revisit the facts in UK Trucks and Stellantis and the Chancellor's decision. But objectivity is the cornerstone of expert evidence. If you can't have it, then I question, as my lord said right at the beginning of this, whether it's expert evidence.
Well, can I put something else to you? A very specific circumstance in UK trucks, which the Chancellor refers to there, is that there was going to be a single entity instructing the expert. So the particular problem that the Chancellor was dealing with was a problem in which RHA was going to have a Chinese wall in the middle of RHA, but then it as a single entity was going to be instructing one person, and you can quite understand why. That's a different circumstance from the situation this court is dealing with, in which you have two independent parties. So there's no problem about the instructions going to the single expert here, because each party can give their own instructions. Whereas what the Chancellor was dealing with was a situation in which one set of instructions was going to come out of the RHA. So it's not the same circumstances, is that right?
My lord, it's certainly the case that the solution that the Court of Appeal was proposing, so the Chinese wall is what the Court of Appeal is saying is sufficient in paragraph 88. The RHA itself is the instructing client, but then there are different firms of solicitors, different counsel and different experts.
What I'm referring to is the passage in 96, in which the Chancellor at the end there, which you just drew our attention to, the last few lines, it cannot be sufficient for the divided loyalty which the RHA owes to the two groups to be resolved by a vague promise that the RHA will decide how to act on the basis of advice. That's a different circumstance. And one can quite see in that case why, when you have this single entity trying its best to represent fairly two independent groups who have a conflict, that raises different considerations from the situation that's in this case.
Yeah. So what they're saying is you can't resolve the conflict between the clients by somehow positing that it could be resolved by input from the expert. It's the other way around. It's for the clients to say what their case is, and then for the experts to objectively opine on the issues arising out of that case.
My lords, I certainly don't seek in any way to take issue with the objectivity of the expert. But in my submission, what the Court of Appeal is recognising here is that is not an answer, because it's saying, without in any way being critical of or doubting the integrity of Dr. Davies, and it is suggesting that in circumstances where Dr. Davies is being asked to exercise his economic judgment, in circumstances where it's highly sensitive to the assumptions made, it's highly sensitive to data input, he cannot be put in the position that he has to exercise his judgment in circumstances where the parties for whom he is acting have conflicting interests. And I don't just to be clear, I'm not in any way advancing a submission that competition as such is special. This is not my submission at all. I'm not advocating competition exceptionalism, but I am saying that the nature of the exercise that an expert economist is being asked to do, it being based on a lot of complex judgment calls as to the information that's put into the model and the way in which the model is interpreted, is such that it's not appropriate for that economist to be put in a position that they are acting for two parties whose interests conflict. Because in doing what inevitably is required in formulating their model, in specifying it, in choosing the variables, in choosing the data inputs, they do have to exercise their judgment.
But can I just, I mean, I think this is a rather interesting fundamental question. And I just question the idea that an expert would choose variables to to put into a model on the premise of the client's interests. It seems to me that the idea of an expert is to help the court reach the correct conclusion as to whether there was an operative cartel, looking at the data that existed between particular time points. And in choosing the data points to put into the model, one is attempting to choose those points by reference to whether or not they will get you the answer to that question, not whether or not it advances the interests of one member of the cartel or another, assuming there was a cartel, at all. And I think that that is the fundamental problem. The nature of expert economic evidence is, and now I'm contradicting what I said, is slightly special. We all know that, and economists do tend to try and tell competition tribunals how to decide their cases, so they tend to encroach. I mean, this is just born of years of experience of seeing it in action. They tend to encroach on the courts, the tribunals' function. But I mean, that's just because it's all a bit of a melee where the law and the economic input is not readily disentangleable. Nobody is to blame for that. But I am concerned with the idea that I think the key point, I'm sorry to say it again, is the choice of parameters is not something that should be made by reference to a client's interest.
My lord, I don't disagree with that at all.
Thank you.
I
think that's
absolutely accept that that is
Yeah.
the case. The problem in my submission is a different one. It's absolutely right that in attempting to exercise their economic judgment, the expert owes a duty of independence to the tribunal and must attempt to come up with the best possible answer to the issues that they're being asked to adjudicate, to express an opinion on. The difficulty arises if, in attempting to do that exercise, they find themselves in a position in which one answer may favour the interests of one defendant and one answer may favour the interests of another defendant, and they absolutely are not permitted to determine their exercise of judgment on that basis, and yet nevertheless they are in that position. That, in my submission, is the problem, and that they shouldn't be put in that position. It's not appropriate for them, in attempting to assist the tribunal independently, to find themselves in a situation where the exercise of their judgment can have those consequences.
Well, you see, you say that, but you know, I was brought up in the day when the duties of experts was less clear, and people regularly in commercial litigation would get an expert, whether it was a merchant banker or an accountant or a goodness knows what, a foreign lawyer, or lots and lots of fields. And the expert would say, under the cloak of privilege, well, you're bang wrong. My expert opinion is that your case is unarguable on this point. And they would then sack that expert and shop around until they found another expert in the foreign law or the accountancy or something else who said what they wanted to hear. And that was totally unhelpful to the court. And so, starting with the Icarian reefer, we started, in civil procedure terms, to clamp down on how experts were instructed. And the reason I make this point is that you are suggesting that because the expert who is instructed forms the view that one of the clients is wrong, that is somehow inappropriate. In fact, it's totally appropriate. And the court should know that, because that's what this independence and the Icarian reefer and the principles that have developed from it mean.
My lord, I am not suggesting that in the event that the expert forms a particular opinion, they should not then pursue it. In my submission, the difficulty arises at the point when the expert is attempting to formulate an opinion. And the expert faces a difficulty that there is no right answer. We've seen that expressed to the tribunals that have had experience of these exercises. There isn't a right answer. And so the expert cannot simply say, well, it's clear to me that the answer is X and it doesn't matter to me what the positions of the relevant defendants are. They are attempting to exercise their judgment in an area where there is no obvious right answer. And in trying to reach the point where they reach a conclusion, before they formulated their conclusion, they are put in a position where the outcomes of their exercise of judgment might have consequences for their clients. And that, in my submission, is the difficulty. It's not a position that they should find themselves in.
That's also their job. I mean, it queries two things. One is it really expert evidence or is it factual evidence? And two, what's wrong with that? Because if you had a single joint expert in this case, the tribunal's position would be much easier. It would say, well, the experts have given me expert evidence that the regression analysis looks like this, and I'm starting from there and deciding the case according to that if I accept that single joint expert's advice as to the expertise. But I think we've reached the point where we understand one another. I mean, I get why you're saying that the difficulty arises when the expert is attempting to form an opinion. But of course, if in forming the opinion, they have to do so independently and not by reference to their client's best interests.
My lord, that is entirely the problem. I don't resist that proposition for a moment. I do, in my submission, I do resist the suggestion that this would be factual evidence rather than expert evidence. It is expert evidence because it is an area of expertise which requires judgment in how to formulate the model, in what data to input, those matters.
You know, we had this argument years ago in accountancy negligence cases, and in share, a lot of cases where expert accountants gave evidence, and they would swear blind that they were giving expert evidence because they'd made calculations. But the truth is that even however complex the calculation, the making of a calculation is a factual matter. The only expert part of it is deciding what parameters to take, as you are saying.
My lord, yes, I think we are in agreement on that element of it. It's not the fact of the calculation, it's not the number that pops out of the black box.
No.
It's how do I set my black box up? It's what matters do I need to input into this to enable it to give an insight into the causal factors that are an issue in this case? What data should I put in? Which periods of time should I be looking at?
But if you accept, I think you sort of half accept, but you perhaps, my lord, took you off the ball there by asking you to focus on the point particularly. If you accept in reality that you cannot choose the parameters by reference to your client's interests, but only by reference to your expertise, then I don't see that the conflict of interest between the two clients is indicative of needing two experts.
My lord, my submission is that it does, because the nature of economic evidence is that it has the characteristics identified by the Court of Appeal. There is no right answer. It is an exercise of judgment, and the expert should be able to exercise that judgment independently, but without operating on his mind the fact that he's being put in a position where the outcome of his exercise of judgment has consequences for either one party or another for whom he acts. He should not be put in a position that is the consequence.
Well, then I get that. Then why is it not a question of case management for the tribunal to decide whether it wants the benefit of two experts doing the same exercise independently of their client's interests when it has the problems that the tribunal identified in its judgment, namely, I've got to distinguish between 3 regression analyses instead of 2, and 2 is more than enough already.
My lord, that is, in our submission, a case management assessment. judgment, that is of a different order than a situation where the expert is being asked to opine where there is a conflict of interest. We do make the submission that that is not a pure case management assessment, that is a question of law, and that it is not appropriate for the expert to act for two parties whose interests are in conflict, because it does put them in an invidious position in complying with their exercise of independence to the tribunal and in exercising their judgment.
Okay.
My Lord, it might assist if we look at the pleadings in this case and identify where we say the conflicts arise. Can I ask the court to pick up the additional, what's described as the additional fresh evidence box, which behind tab 1 should have the latest version of the pleadings for the claimant.
Sorry, the additional fresh, is it called additional fresh evidence bundle?
My Lord, yes.
Yeah, okay.
It's tab 1, and your Lordship should have behind that the fourth amended particular claim.
You haven't devised some method in the Competition Appeals Tribunal to do away with these silly colours?
My Lord, to be fair, it was I am responsible for having all the colours in the version that I've chosen to show the court, and the reason is that I want to draw a distinction between the pleaded position as it was before the tribunal and the position as it is now. So I'm afraid I'm responsible for the multicoloured approach.
What do you do with colourblind judges?
Cannot say I've ever come across that situation.
No. You're all right today, apparently. At least nobody's making any admissions.
I have seen approach where one has little subscript numbers or superscript numbers indicating whether it's the First Amendment, the Second Amendment.
It's a nightmare. Okay, on we go. Sorry about that, Dad.
Can we start paragraph 9? Paragraph 9 is the summary of the claimant's claim. And it says the claimant's claim as pursued herein is that the defendants were parties to a cartel or series of cartels concerning sales of OSS, that's occupant safety systems, products, which was in operation between as early as 2002 and in any event from 2004 and 2011. So that's an encapsulation of what their claim entails. Paragraphs 18 to 28 in this document.
Is it right, I'm sorry just to clarify something, but is it right what was said in the respondent's latest skeleton, that it's not now alleged that the two groups who remain as defendants, that one of them was party to a cartel that the other was not, or vice versa?
My Lord, yes, that's the reason I wanted to show the court the amendment that's been made. It is correct, but our submission will be that that doesn't change the underlying position, which is this case as a whole is drawing very heavily on commission decisions where the defendants' positions are very different. And so it's essentially papering over the cracks. But I'll come on to make that submission.
Okay, thank you.
By way of illustration, we have here the claimant's pleaded case on the two commission decisions. So they're defined as OSS1 and OSS2, and what the court will notice immediately is that we are a long way from what might be called the conventional case, where there is a single market-wide cartel to which all undertakings have been found to be a party, because we here have 6 different infringements. They involve different products, they involve different suppliers, they involve different OEMs, and they involve different time periods. So paragraph 20 summarises the OSS1 decision. The Autoliv undertaking was an addressee of OSS1 and ZF was not. And the OSS1 decision makes 4 findings of infringement, which relate to different products and to different OEMs. So we can see there's a supply of seatbelts to Toyota, the supply of airbags to Toyota, the sale of seatbelts to Suzuki, and the sale of seatbelts, airbags and steering wheels to Honda. None of the supplies were to the claimants. The undertakings found to have participated in each infringement differ. So Autoliv was found to participate in the first, second and fourth infringements. And the court will see that the periods of participation differ within each infringement and between each infringement. And the commencement dates range over from a period of 2004 to 2008, and the end dates are over a period from 2009 to 2010. So that's the OSS1 decision. The court then turns the page, paragraph 24 summarises the OSS2 decision. Both Autoliv and ZF were addressees of OSS2, and that decision makes two findings of infringement in relation to the sales of seatbelts, airbags and steering wheels to VW Porsche, and in relation to the sale of seatbelts, airbags and steering wheels to BMW Mini. And again, none of the supplies were to claimants. Again, we see that the periods of participation differ within each infringement and between each infringement, and the court will note that the start dates of the OSS2 infringements are in broad terms later, so they date from 2007 and 2008, whereas some of the OSS1 infringements were dating from 2004 to 2006. And the periods of participation for ZF and Autoliv for the BMW Mini infringement are different. So Autoliv, the period is 28th of February 2008 to 16th of September 2010, and for ZF it's 5th of June 2008 to the 17th of February 2011. So, in our submission, if there ever were a case where the defendants are very obviously differently placed, this is it. It's not a classic case where there is a single standalone cartel. I'm sorry, a single market-wide cartel, I should say. The claimant's allegation of a standalone cartel is then in paragraph 39. This is the paragraph where we have to distinguish between the position before the tribunal and the position now. The period pleaded is from the 6th of November 2002, so earlier than the OSS1 infringements, and very much earlier than the OSS2 infringements, and then until 30th of March 2011. And the allegation is that there were agreements or concerted practices to prevent, restrict or distort competition in the supply of OSSS products to automotive OEMs, including the claimants. And so the relevance of this is it's going much further than the commission decisions, which were not addressed to the claimants, and it's alleging a cartel which was directed at the claimants. The allegation, as it was before the tribunal, was that the parties to the alleged agreements and concerted practices were the undertakings to which the addressees of the decisions belonged, and then the words that are struck out, or any two or more of them in combination. And that raised the possibility that two of the defendant groups were a party and the other was not. After the tribunal's ruling, and one assumes with one eye on the conflict of interest issue, the pleading was amended to its present form, and the allegation now is that there was a group of undertakings which at all times included Autoliv and ZF. The RW.
Would you accept that we've got to proceed on the basis of the amended pleading? I mean, it's certainly educational for us to appreciate how matters have evolved, but we've got to proceed on the basis of matters as they stand now, have we not?
Well, my lord,
particularly given that we, as everybody knows, there's been a second ruling from the CAT in which they've maintained their position on the basis of the amended pleading.
my lord,
Therefore,
yes.
let it be assumed that the first ruling was flawed. We would still have to consider the position in the light of the second.
My lord, yes. So my submission will be that if one looks at the pleading as a whole, and when we come to it, the claimant's expert evidence, although the attempt is made to suggest that there is now one unified case advanced as against both defendant groups, such that they are both in the same position in resisting it, actually that's not the case, because the allegation is all tangled up with the claimant's reliance on the commission decisions, in relation to which the defendants are very clearly differently placed. I've shown you the passages where there's reliance on the commission decisions in this pleading, but I'll come on to show the court the claimant's expert evidence, where it's very clear that they are drawing on and buttressing their allegations by reference to the commission decisions, where the defendants are simply differently placed. Just to complete the relevant paragraphs of the pleading, there is then paragraph 43. And this is an alternative case that if the cartels were limited to supplies to individual customers, then they would say there were separate cartels with the same membership concerning supplies of products to the claimants. And then paragraph 44 is pleading a further alternative case, which is that even if there were no cartels which were actually concerned with supplies to the claimants, the effects of the cartels established in the Commission decisions would have been to increase the prices charged to OEMs other than those that were the targets of the particular cartels. And this is the umbrella claim. So even if it wasn't directed at us, they say the effects of the cartels would have been to raise prices to us. And paragraphs 44A to 44G are said in paragraph 44, they say further particulars of the mechanism by which prices were thereby increased are set out in paragraphs 44A to 44F. So those are the relevant paragraphs describing what the claimants say is a pricing mechanism whereby cartels not directed at them had effects in respect of products provided to them. Paragraph 76, sorry, pick up on the way past paragraph 46. This is the paragraph which pleads that each defendant which is party to the cartel, or if there was more than one cartel, each such cartel is jointly and severally liable, all other parties to that cartel.
Can you give me that paragraph number again?
I'm sorry, my lord, it's 46.
Thank you.
And this is the paragraph which pleads joint and several liability. Paragraph 76 is the paragraph which pleads that the cartels had the effect of increasing the OSS price the price of OSS products that had been purchased by the claimants. And then paragraphs 79 to 84 are the paragraphs which plead an undifferentiated claim for the entirety of the loss that's claimed to have been suffered from each of the defendants on the basis that they are jointly and severally liable. In our submission, this pleaded case gives rise to 3 relevant conflicts of interest. I'm going to identify them and then address them in turn. First, if one takes a straightforward classic cartel to which all the defendants are a party and for which they're all jointly and severally liable, then we say the conflict of interest between them arises in respect to the question of apportionment of any losses. Secondly, in a more complex scenario, there may be differences in the extent of the defendant's respective liability, and the defendants will then have conflicts of interest in terms of minimising the extent of their own participation or liability, and potentially also maximising the liability attributable to their co-defendants. And thirdly, we say that the claim for umbrella damages arising from the alleged effects of the OSS1 and OSS2 decisions gives rise to a conflict as to whether any umbrella effect is attributable to infringements for which each defendant was a party or to an infringement to which they were not a party. And so there again in our submission there is a obvious conflict of interest between them. So starting with the question of apportionment, this is a conflict which arises in every cartel in which the participants in the cartel are jointly and severally liable. In every cartel, a question arises as to how total liability to the claimant should be apportioned as between the participants to that cartel, and each participant will have an interest in minimising their share, and that interest will be directly in conflict with the interest of every other participant who is also seeking to minimise their share. We say that that conflict does arise on the face of the pleadings because of the way the claimants have pleaded their claim. We say that by pleading a single undifferentiated claim for alleged losses, which they say they're entitled to recover jointly and severally from both defendant groups, and by not allocating their claim as between defendant groups, which they are obviously not obliged to do, that necessarily and inevitably raises a question of how in practice that liability is to be borne as between the two defendant groups. We fully accept that there are no currently pleaded claims for contribution as between the defendant groups, but in our submission this is a conflict which arises irrespective of any currently pleaded claim for contribution, because it is an obvious and unavoidable issue when claimants pursue an undifferentiated claim against independent defendant groups. And we say it would be a perverse and highly wasteful incentive if defendants who find themselves in this position are obliged to incur the time and cost of commencing contribution proceedings solely in order to show that there is a conflict of interest between them, and so to be entitled to instruct their own expert. In our submission, this is not a problem that can be sidelined and dealt with later, because the reality of the matter is that the expert evidence in these proceedings is highly likely to have a bearing on the question of apportionment as between the defendants, and that is the expert evidence which will be impacted by the conflict of interest. The Civil Liability Act makes specific provision to that effect. It's in the Authorities bundle, tab 8. The court will be familiar with the headline entitled Contribution under Section 1.1, that any person liable in respect of any damage suffered by any other person may recover contribution from any other person liable in respect of the same damage, whether jointly with him or otherwise. And then, if we look please at Section 1, subsection 5, we have a provision that a judgment given in any action brought in any part of the United Kingdom by or on behalf of the person who suffered the damage in question against any person from whom contribution is sought under this section shall be conclusive in the proceedings for contribution as to any issue determined by that judgment in favour of the person from whom the contribution is sought. So just breaking that down a bit, the person who suffered the damage in question is, on their case, the claimants in these proceedings. The action in the United Kingdom has been brought on the claimant's behalf against the two defendant groups. One defendant group may in due course wish to seek contribution from the other defendant group, and this provision provides that the tribunal's judgment in this action shall be conclusive in the proceedings for contribution between the defendant groups as to any issue determined by that judgment in favour of the person from whom contribution is sought. So the defendant who is seeking contribution in due course is bound in those proceedings by findings of the tribunal in favour of the contribution defendant. So we say in those circumstances the expert evidence in these proceedings is clearly likely to be relevant to any eventual claim for contribution, and that is not, in our submission, a purely theoretical concern, because the claimant's evidence has already traversed matters which are relevant to the extent of the relative responsibility of each of Autoliv and ZF. The claimant's expert report is in the additional fresh evidence bundle behind tab 9. Can I ask the court to start, please, on bundle page 106. There should be a heading there, overspend and damages. Section 1.9, overspend and damages. And this is the section of the report which is summarising the claimant's case on overcharge. And at 1.9.2, the claimant's expert makes the point that although for convenience this table splits the loss by supplier, I understand that the claimant's case is one of joint and several liability, meaning that Autoliv is equally liable with TRW for TRW supplies and vice versa. That is, of course, the claimant's preferred approach, but it doesn't mean that the material that the expert goes on to set out will not be relevant to the defendant group's positions vis-à-vis each other. And so if the court turns over, there are two tables. Table 1.5 is headed estimated overspend by defendant and product category in millions of euros based on the claimant's value of commerce data. And that breaks down the data within it by defendant group. And then table 1.6 is headed estimated overspend by defendant and product category in million euros based on the defendant's value of commerce data. And again, it breaks matters down by defendant group. that's the summary section. We then have the entirety of section 6 of the report, which begins on page 183 of the bundle. And this is where there are detailed conclusions on the alleged overspend. Section 6 begins at page 183, estimation of overspend, but if we go to page 185, we see starting 185, table 6.2, and then over the page 6.3, and over the page 6.4. They set out the estimated overspend for each of the claimant groups, and in each case they break it down by defendant. And above each table there is then given a total figure for AUTOLIV and a total figure for ZF TRW. We go on to page 7. We see additional figures are then set out for the alleged overspend using defendants' data. So table 6.5 over the page, and table 6.6. And in our submission, the fact that this report gives two differing figures, the claimant's data and the defendant's data, tells us that this is not a straightforward factual inquiry. It's not an uncontroversial factual exercise. One can come out with different answers, and of course even the claimant's expert has done so. The interest calculations are then broken down by defendant. You can see that table 6.9 on page 195. 6.9 is PSA, and then we have 6.10 on page 196, FCA, and 6.11. Each of those breaks down interest by defendant and product category. And then page 198, we can see table 6.13, 6.14 on 199, and 6.15 on 199, which are giving total damages, again broken down by defendant. Now, it goes without saying that the defendants would want to respond to this exercise, and it's also in my submission self-evident that their interests are not aligned when they do so. It's also important to remember that questions of apportionment between defendants aren't limited to questions of their respective sales. They can also take into account a defendant's relative role in the cartel. And we have, for the court's note, cited a recent judgment as authority for that, the Court of Appeal in Samsung Electrics, which is in the Supplemental Authorities Bundle, tab 1, page 6. The claimant's expert has also purported to pass comment on contemporaneous documents originating from both defendant groups. And I don't invite the Court of Appeal to get into the detail of this, but I do rely on it to show that this is the sort of material that has been deployed by the claimant's expert in support of their case. So, for example, if we look at page 119 within this report, see there 2.4, heading evidence of explicit coordination and information exchange in relation to the claimants. And if the court turns over the page and runs its eyes down the subparagraphs, what it will see is that the claimant's expert is commenting on contemporaneous documents originating from each of the defendant groups. Now, the defendants will have to respond to what the claimant's expert has sought to make of this material. It's possible that the defendant's expert or experts may be cross-examined on it. It goes without saying that we strongly resist the conclusions the claimants seek to draw from it. But if the claimant's case were to be accepted, then these documents and what's being said about them potentially go to the relative role of each of the defendant groups in the cartel. And in responding to those, in our submission, the defendant's interests are fundamentally in conflict. So in our submission, a clear conflict arises on questions of apportionment as between the defendant groups, even if one is simply assuming a straightforward cartel to which both defendants are a party. As we've seen from the pleadings, this is in fact far from a straightforward cartel claim. And that, in our submission, means that there is an even greater risk of conflict of interest. We would say it's an actual conflict of interest as between the defendant groups in responding to the case that's being advanced against them. I've shown the court the way in which the pleadings rely on the Commission decisions, in relation to which the defendants are very obviously differently placed. But the same is true of the expert report. So if we start, please, page 97 in this report. Paragraph 1.3.2 is simply explaining what the expert means when he uses the phrase cartels. And he says, I assess and evaluate the potential damages that the claimants may have suffered as a result of having purchased occupant safety system products that may have been affected as a result of the cartels, a defined term, including but not limited to those described in the two settlement decisions, together the EC decisions. So every time he refers to cartels in the subsequent document, he's referring both to the Commission decisions and to the standalone allegations that the claimants are advancing. We turn to page 98, section 1.4. We can see a heading, the operation of the cartels as described in the EC decisions. And the expert there is describing the cartels, which he defines so as to include but not be limited to the EC decisions, and he's drawing heavily on the content of the EC decisions as to how it's alleged those cartels operated. The same applies in section 2 of this report. So if we look at page 109, there's a heading, theories of harm, and within this section, over the page at page 111, there's another section that says the operation of the cartels. This refers back to section 1.4 that I've just shown the court. It says, as explained in section 1.4, the EC decisions describe the nature of the cartels and how they affected the named OEMs. And it said in particular they highlight the implications of the cartels in the context of RFQs launched by the named OEMs and PAs negotiated with them. This does not mean, however, that the cartels only affected the named OEMs, and this is the section where the claimants go on to make out, to set out their position on their standalone case. But in doing so, they are heavily drawing on matters that are set out in the Commission decisions. And so in our submission, although the claimants would like to present their primary case as being a straightforward and clean scenario whereby both ZF and AUTOLIV were involved equally and to the same extent and therefore cannot have a conflict of interest, actually that case is all jumbled up with all the other elements of the case that draw heavily on the Commission decisions. And the court has the point that insofar as there is reliance on the Commission decisions, the defendants are very clearly not identically placed. They participated at different times, to different extents, in relation to different OEMs and different products. Again, we say this isn't just a theoretical complaint because it has concrete consequences in terms of the expert's overcharge methodology. And we can see that from the approach that the claimant's expert takes, in particular to the start date of the cartel. So if we start, please, at page 140 within this document. There is a heading there, factors to consider when analysing whether there have been cartel overcharges on the claimant's OSS product prices. So this is in the section where he's setting out his methodology to try and determine whether there's an overcharge. And paragraph 2.8.2, he says, in this case, the precise start dates of the cartels, including any associated tacit coordination thereby facilitated, are uncertain based on the contemporaneous documents disclosed by defendants and vary across product categories. He goes on to say these varying dates suggested should be tested whether new contract and amendment overcharges started earlier than the dates indicated in OSS 1. And the dates that he proposes to look at, if one looks at each of the subparagraphs A, B and C, which follows, each of them is then taken from the OSS1 decision, the earliest collusion dates for steering wheels, seatbelts, airbags in OSS1. The court will appreciate that one of the defendant groups is party to OSS1 and one of them isn't. And so the defendant group's position as to whether this is the appropriate start date for the economic analysis might well differ. And the same problem then arises in relation to end dates. If we go over to 142, paragraph 2.8.4 is dealing with end dates, and 3 out of the 4 end dates that the claimant's expert is proposing is appropriate, derived from OSS1. If we look please at page 175, there's then a heading capturing the impact of uncertainty as to the start date of the cartel period. And this is where the claimant's expert explains the impact of these considerations on his own methodology. And what he does is he explains he's going to seek to control for a different possible overcharge during the early period, what he defines as the early period, as distinct from the main period. And he says this is important, as neglecting this uncertainty could result in an underestimation of the overcharge if the cartel was operating over this longer period, or prices were otherwise higher in the early period for reasons not captured in my econometric models as I rely on before, during and after data to maximise the number of observations I have. So he's saying these are important judgment calls he's making. The way he does it is to define different periods in his model, but exactly how those periods might be defined and which dates are appropriate, first of all, might well have a material impact on the results, and secondly is a question in relation to which the defendants might well be very differently placed because of their different participations in OSS1 and OSS2. We go on to page 182. This is where the expert sets out his conclusions. And what the report does is that it finds different overcharges, first of all for different components, and secondly for different periods. And that, in my submission, makes it highly relevant that the defendant groups are liable under the OSS decisions for infringements relating to different components and different periods. And so, again, they're not similarly placed in seeking to respond to this material, and the judgment calls that the expert will be called upon to make, the ways they might formulate their model to try and get at these issues, will be impacted, in my submission, by the fact that the defendants are in different positions. So that's the second head of conflict of interest. Finally, we say there's a conflict of interest in relation to the umbrella damages claim. The defendant groups can only be held liable for umbrella effects caused by the infringements in which they were found to participate. They cannot be held liable for umbrella effects caused by infringements in which they did not participate. And because the defendants have been found to participate in different infringements, they will each have a differing interest in challenging the causal link between any umbrella effect and the infringements for which they, in particular, have been held to be responsible. Now, one way in which the defendants might seek to do that might be to focus on the periods of time over which each infringement operated. So if we were to go back to the summary of the relevant periods that's in the pleading, Fresh Evidence Bundle tab 1, page 12, we can see from the table that summarises the OSS1 decision that Autoliv was found to participate in the fourth infringement from the 28th of March 2006. If we turn over to the table summarising OSS2, the earliest period of participation in OSS 2, to which the ZF undertaking was an addressee, was the 4th of January 2007. And so there is a period from 28th of March 2006 to 4th of January 2007 when ZF would wish to say that any umbrella effect could not be attributable to any infringement in which it has been found to participate. But the point doesn't stop there, because the next step would be, well, if any overcharge over that period cannot be attributable to both OSS 1 and OSS 2, there's then a question, well, does that cast any light on the extent to which the overcharge in the overlapping period, the period where both of those infringements were operative?
Ms. Ford, sorry, forgive me, can I just make sure I've not misunderstood something? I understand the point you've made that based on these dates, TRW would like to, TF would like to say, or ZF, sorry, would like to say that whatever happened before the 1st of January 2000 wasn't its fault. I get that. But how does that, I understand that point. How does it play out with the fact that the pleaded case against you requires there to be a cartel which they're both participating in?
Well, this arises on the umbrella damages claim, so it's not the standalone claim. There is a question that the tribunal has raised as to whether or not there is a pleaded case on behalf of the claimants for umbrella damages over this period. If there isn't, then neither of the defendants will be liable in respect of, of that period. But this goes to a slightly different point, which is, given that there is a period of time when only one of these infringements was operative, does that enable the model
No, I understand that.
to learn? So it's not really about liability and pleading at that stage. It's about, can the model be used to ask about the causal effects of the overcharge in the overlap period for which there is a pleaded case, because we know that any overcharge, any umbrella effect in the early period could not be attributable to one of the decisions. And so it does raise the possibility that one can interrogate the model and ask about causal effects as between different defendants. That's one way in which one might seek to get at this question of, well, what is each defendant liable for? Even for the period of time during which the infringements overlap, there might also be other ways in which the question of causation could be explored. One example is the pricing mechanisms that the claimants have pleaded, their positive case as to how they say it's possible that the infringements directed at different OEMs might somehow have affected them. Now, it's possible that those pricing mechanisms might be more likely to operate in relation to some infringement than others. And again, that's something that the defendants are entitled to explore with their experts. So in our submission, there is a third obvious conflict of interest here, which we would submit precludes requiring the defendants to share a single expert. Now, I'm going to move on to address how the tribunal dealt with this issue. And as the Court of Appeal may have seen from our skeleton argument, the issue actually arose in something of an unorthodox way. At the second CMC in these proceedings on the 28th and 29th of March, the tribunal raised for the first time of its own motion the possibility of confining the defendants to a single joint expert.
Yeah, can you just help me on that? And this is my ignorance, for which I apologise. Does Part 35 not apply to the CAT? CPR Part 35?
The CAT has its own procedural rules.
I know it does, but I'm not sure. That's why I'm asking the question. And as I say, it's my ignorance. I'm sure I should know the answer, but I'm slightly puzzled as to whether the CPR and particularly Part 35 apply or not.
Part 35 being the independence.
Part 35 is what regulates expert evidence.
Yes, and including the expert duties to the tribunal.
Among other things.
Certainly, it's never been suggested that the tribunal is any different position than the High Court in that respect, although it does, when ruling on these issues, draw on its own rules rather than...
Right, so is it common ground, therefore, that the starting point is you can't adduce expert evidence without the permission of the tribunal, and that the control of expert evidence is a matter for the tribunal.
We don't take issue with those propositions, and the tribunal does record that in its judgment.
Thank you.
What we say is that the presence of a conflict of interest is a factor which overrides any case management type considerations as to what might be a preference for the tribunal to only receive, for example, one report rather than three.
Thank you.
So just recounting how this actually came about. The issue arose in exchanges with the tribunal of its own motion rather than any sort of formal application. And so the point was made that given that we had not had a fair opportunity to respond, we asked the tribunal to give the defendants a proper opportunity to deal with it. And so the tribunal indicated that it would not make an order on that occasion. But when we received the CMC order from the tribunal, it then contained paragraph 17, which only granted permission for the defendant groups to rely on the evidence of a single expert. And the tribunal's explanation was in its letter of the 16th of May, which is in the supplementary bundle, tab 4, page 121. The tribunal says, the first is a matter which was raised briefly by the tribunal at the end of the CMC, in which the tribunal indicated might required revisiting. That is the number of experts in the field of competition economics in respect of which the tribunal would give permission. The tribunal has decided to give permission only for one joint expert for the defendants, and they will be required to cooperate in instructing that expert. It is highly unsatisfactory that the claimants or the tribunal should have to consider three different approaches and or economic models from the defendants. The tribunal appreciates it has not heard full argument on this issue, so if the defendants object to this course and can provide substantive reasons as to why there should not be a single expert, they have liberty to apply. So that is the first of a number of mentions of the tribunal's preference only to see one expert report from the defendants rather than multiple. And we duly made applications to vary the order, which were then heard at the third CMC on the 20th of October 2023. The ruling is in the core bundle tab 5. We start, please, with paragraph 14. The tribunal is basing its approach on the governing principle in Rule 4 of the CAT rules to deal with cases justly and at proportional costs. And it points out that
Yes, see, that's one of the things that I find a little puzzling, because being ignorant, I would have expected the CAT to start with Rule 35.1. Expert evidence shall be restricted to that which is reasonably required to resolve proceedings, which is why I start wondering if maybe the answer to my question is Part 35 doesn't apply.
My Lord, it does. The tribunal is here citing the Competition Appeal Tribunal Guide 7.65, and that says, as regards expert evidence, the tribunal will take into account the principles and procedures envisaged by Part 35 of the CPR. Notably, that expert evidence should be restricted to that which is reasonably required to resolve the proceedings. So it is cross-referred.
Sorry, is that 7.65 of the tribunal rules?
It's the guide.
The guide. And where do we find the guide?
I don't believe we've included that in the bundle, I'm afraid, because we didn't think it was particularly in issue.
Well, it's on the website.
It is indeed, yes.
Guidance, competition appeal, guide to proceedings. And you say 7.65?
That's the paragraph the tribunal is quoting, paragraph 14, my Lord, yes.
Yeah, but see, this is I apologise for, as I say, ignorance, but it seems a bit odd to refer to a guide, and I emphasise the word guide, which says the tribunal will take into account. I mean, this seems, as I say, to proceed on the assumption that Part 35 doesn't apply, but it's being treated as persuasive.
Well, I think it's right that the strict position is that Part 35 is not binding on the tribunal, because the tribunal is a creature of statute. It applies its own rules, but it has indicated in the guide that
There's a more general provision, Ms. Ford, in the guide, which said 3.2. It says the rules pursue the same philosophy as the CPR of the High Court, and many of the rules are modelled on the CPR. And then it says it mirrors the CPR. But that would infer that the actual CPR rules are not directly applicable. So that if you then go to 7.6.5, what it actually says, I can just turn it up, is the tribunal will take into account the procedures, notably that expert evidence should be restricted to that which is reasonably required to resolve the proceedings. But it's for the party seeking to call expert evidence to satisfy the tribunal that expert evidence is properly admissible and relevant. And then there are rules in the CAT rules which deal with expert evidence.
My lord, yes, and the tribunal cites one of those,
Exactly.
Rule 53 to E.
Yeah. So I think the answer to the question is that they're not directly applicable, but in essence, it is intended that the spirit of them have been read across.
My lord, yes, save insofar as there is a deliberate departure, but we don't seek to suggest that there is such a relevant departure in the circumstance of this.
So you would accept, I take it therefore, that although it doesn't strictly apply, Rule 35.3, paragraph 2, the duty of the experts to help the court overrides any obligation to the person from whom experts have received their instructions or by whom they are paid, is also applicable.
My lord, yes, we don't seek in any way to take issue with the obligations of the experts, their independence, their duty to the court or to the tribunal, and our position will be it applies equally in the tribunal.
If their duty to the court overrides any obligation to the persons from whom they've received instructions or by whom they are paid, why is it that there any possibility of conflict between two instructing parties is of any relevance?
My lord, because in seeking, it is essentially the answer that I gave the court earlier, and I do continue to rely on the reasoning of the Court of Appeal in relation to this. In seeking to reach a considered position on the issues of judgment that they have to take into account, the expert should not be put in a position that the outcome of their exercise of judgment and the calls and the decisions that they have to make may have differing consequences for different parties for whom they act. That, in my submission, is not a position that the expert should be put in. And that is notwithstanding, and then, as I emphasise, I don't take issue at all with the proposition that the expert owes their duty to the tribunal.
It would be helpful if we were, I mean, I've got it online, but it would be helpful if we were provided with the rules and the guidance.
We
Please,
can certainly do that.
thank you.
There isn't a general, I mean, some tribunals have a rule that says something like if nothing else applies, the CPR applies. There isn't one of those in the CAT rules.
I would have to check in order to...
I checked. I don't think there is.
I'm grateful.
But you'll correct us after lunch, Ms. Ford.
We can certainly check over lunch in case that's wrong. I'm certainly not in a position to make a submission on the position either way at the moment. I was showing...
Forgive me, Ms. Ford, and there might even be authorities dealing with that question, I don't know. That aren't to do with a specific issue, but the general point.
Yes.
As to...
The
Whether
extent to which
CPR.
the CPR apply in the CAT.
Yes, well, we can certainly try and verify that as well. It may be that that's a slightly more lengthy exercise.
Well, I'm not sure. I mean, I remember some recent cases where some hugely procedural issues have been litigated in front of me. But I sort of remember the CPR being pretty much in evidence.
It's certainly frequently referred to. As the tribunal records, I actually cited a number of cases from the High Court that appeared under CPR. So paragraph 15, it's referring to the approach in relation to a single joint expert.
I mean, we may be able to agree that the principles of when you need expert evidence, what expert evidence is, and what the duties of the expert to the court is no different in the days of one judiciary between courts and tribunals. I mean, the exercise that we're seeking to achieve in the tribunal is the same as in the court. So I suspect there isn't really any difference of principle unless there were a rule that specifically applied here, which there doesn't seem to be.
It's certainly no part of my case that the outcome of this appeal turns on some sort of procedural specificity in the CAT. My submission would be that the same would apply if I were seeking to produce expert evidence in the High Court.
I mean, for my part, the issue does seem to me to be whether you're right in saying that inherent conflicts of interests between defendant groups is sufficient to indicate that it would be, as a matter of case management and indeed of law, or maybe as a matter of law, wrong to require you to have the same expert. And you know, we had a discussion about that this morning.
My Lord, yes, that encapsulates the point. We do say that, insofar as we're right on that point, there are clear conflicts here that satisfy that requirement. And so...
we've seen the argument, yes, and we've been through it all now.
Just a last question on this theme. You helpfully drew our attention a second ago to paragraph 15 of the first ruling and the cases you cited under the CPR. Would you accept, therefore, that even if it's not directly applicable, the CAT has the same power as the courts have under Rule 35.7, paragraph 1, where two or more parties wish to submit expert evidence on a particular issue, the court may direct that evidence on that issue is to be given by a single joint expert. So in other words, even if the parties are agreed that they should have their own experts, the courts can say, no, we don't accept that you should have your own experts. I'm going to impose a single joint expert on you.
I accept that the court has such a discretion, subject, in my submission, to questions of conflict of interest, in relation to which my submission remains that whether under the tribunal approach or the High Court approach, a conflict of interest would be a situation where it would not be appropriate for the court to impose that requirement on the parties. I did
slightly... I don't understand that, because as I think it was my Lord Justice Birss pointed out earlier this morning, single joint experts are typically directed as between claimant and defendant, where there is axiomatically a conflict of interest.
My Lord, yes,
so if your submission is that Rule 35.71 has to be read on the basis that it doesn't apply where there's a conflict of interest, it would never apply in most of the cases where it's used.
My Lord, yes, one does have to narrow it down slightly beyond a conflict of interest in the sense of being opposing parties. And in our submission we have done. It's not a conflict of interest in the abstract. And indeed, if one would simply be saying it's a conflict of interest for opposing parties, that doesn't necessarily apply to co-defendants. What we say is that this is expert evidence which goes to the question of the existence or otherwise of an overcharge. And in relation to that particular issue, there is a relevant and material conflict of interest between the defendant groups. One does, and this question about what level of granularity one analyses the conflict of interest, well, it comes up again in the tribunal's second ruling, because the tribunal appears to be taking, in my submission, the opposite approach and saying that unless one can identify a an exercise that a single joint expert simply cannot do, then one hasn't established sufficient conflict of interest. And my submission will be that that takes it far too narrowly, and one must look at the level of the pleaded case, as we have sought to do, and identify the extent of any conflict of interest at that level. Equally, though, one doesn't take it at such a level of helicopter generality as to say these are opposing parties and therefore no joint expert. That self-evidently cannot work.
May I ask you a question about Rule 53(2) CE, which, for the benefit of others, says the tribunal may give directions for the appointment and instruction of experts, whether by the tribunal or by the parties. Now, my understanding in the courts is that if you have a single joint expert, the court can settle the directions, but normally the parties would, can settle the instructions to the expert, but normally the parties would actually do the instructing. But it appears that there may be a process in the CAT, which I'm less familiar with, where the tribunal itself instructs the expert. Is that commonplace?
It is not commonplace. I cannot personally think of an instance where that has occurred. And indeed, there is evidence which was before the tribunal for the purposes of these proceedings, both from McFarland's and from White and Case, that there is no instance where the tribunal has directed defendants to share an expert before this case.
Well, they wouldn't be sharing the expert. The expert would be to the tribunal.
I know, yes, and that's in some respects an even more extreme situation.
Well, but I mean, it can't be unlawful as a matter of law, since it's in the rules, that you can do it. And I wonder whether what the tribunal here was driving at was saying this is a funny area where regression analyses are complex and require subjective analysis of data, and we don't want too many of them. And maybe it was struggling for the idea that it should be applying that rule. I can see I'm being incredibly popular with this suggestion. I can see the parties are alive with enthusiasm for it. But the serious point is that it is in the rules, and it is not a single joint expert, it's a tribunal expert, and it cannot be unlawful when it's in the rules.
My lord, yes, I don't seem to suggest that it is not open to the tribunal in an appropriate case to do that. And the tribunal would obviously have to consider what is the matter that the tribunal wishes to be informed about, for which it considers it appropriate to identify an expert, as opposed to the usual adversarial approach whereby the parties seek to present their case or their defence. I don't seek to suggest that it's not in an appropriate case a possibility that's open. And I don't...
It is... I think it would be helpful to look at the rules in their entirety, actually. I'm just looking at Rule 55, which seems to have some relevant material. I mean, the procedures in the tribunal have become more adversarial, even in my short acquaintance with it over 20 years or whatever, 30 years. It is now a very adversarial place, but maybe a slight reset is needed when one considers the fundamental question of whether a conflict between the parties is really anything to do with the nature of expert evidence.
My lord, we would resist that as a proposition, particularly in circumstances where we are facing claims of the order of €1 billion.
Well, does the money really matter? I mean, the fact that it's a big cartel doesn't affect the principles on which justice is done, does it?
My lord, it does matter in the sense that in situations where there isn't a question of conflict of interest, the tribunal will be primarily trying to reach a decision based on proportionality and the overriding considerations in Rule 4. And there, it might well be relevant to say, well, this is a relatively small claim, and therefore it makes sense to prevent the parties from expending time and money adducing competing expert reports. We do say that in a claim of this value, it cannot possibly be suggested that considerations of that nature would properly preclude a party from introducing their own expert when they are facing standalone allegations of cartel conduct, so with serious reputational consequences as well. It's not simply a follow-on claim.
I do get all that, and I get how serious this case is for the people involved, for the companies involved. I think my point is a different one. It doesn't preclude you as a defendant group to this procedure to get advice from as many experts as you want, as many economists, as many data analysts, as many econometric experts, and so on, so as to present your factual case in a way most beneficial to your group. That, of course, is your entitlement. What is being said here is where there is such complexity and difference of approach that it is confusing and difficult and contrary to the basic case management principles for the tribunal to be faced with these completely different and multiple completely different econometric models. And that does not facilitate the fair disposition of the case. And that's a different point. You're not being prevented from getting advice from any number of people and deciding what is most to your advantage in the way you present your case. It doesn't mean the court has to look at those models and use them as their starting point. Which starting point might be better if the tribunal had asked for the model itself, for example?
My lord, it's certainly right that we're not precluded from asking for advice, but the question is then, the parties would wish to then adduce expert evidence, which goes to the question of how does one seek to ascertain whether there is an overcharge in this case, and if so, how much? And simply being able to obtain advice on that point falls well short of being able to adduce expert evidence, which goes to the point. Is it any...
But the expert evidence, I think we're going round in circles here, but the expert evidence is simply an expert's view as to which are the correct parameters to take into account in order to establish whether there has been overcharge in a particular factual situation, right? That is what the expert is doing. And there will always be 200, 300, 400, 500, 200 different views depending on how many people you ask. And that the function of expert evidence is not to have endless numbers of people expressing different views. It is to assist the court to reach a just and appropriate view on the evidence of what were the correct parameters to take in order to answer the question. And if you look at it from that end of the telescope, you don't necessarily come out with the answer that every person who has a conflict of interest with another person in the case must be allowed to have their own expert. You may do, as they did in the trucks case, whichever one it was, but you may not. You may come out with the view that that actually is not just or appropriate. It's disproportionate, not in the sense that there's not enough money in the case to justify it, but it's disproportionate in the sense that it's subjecting the tribunal to needless additional work which doesn't advance what it has to decide, which is a different kind of disproportionality.
My lord, one shouldn't necessarily assume that multiple expert reports either results in duplication or results in needless complexity. In a field of expertise which is essentially contested and involves value judgments, there must be circumstances in which the tribunal might well be assisted by hearing from multiple experts, and the process of reconciling their views, whether that takes place by means of cross-examination or by a hot tub, which is another mechanism that the CAT often favours, assists the CAT in trying to get to the bottom of the ultimate issue before it. In my submission, one shouldn't automatically proceed on the assumption that more is worse. In some circumstances, more may be better.
Except this tribunal thought very clearly on two separate occasions that more was worse and did not contribute towards good case management or just decision making. And we have to give, I think you'll accept this point at least, we have to give as much in an appeal from the CAT as in an appeal from anything else, and indeed probably more, respect to the expert tribunal that is deciding the case. So it's only really, which is why you put your case as a matter of law, if they've made a mistake of law, that you could even get here. And I mean, you got a very strong permission to appeal from Lord Justice Popplewell, who said this was wrong. So we would be, if we decided not to allow the appeal, we would be going against him. But I'm just saying it has to be a question of law.
My Lord, we accept that that's the case, and we do say that this raises a question of law.
Yeah.
And that overrides case management preferences.
Yeah. Well, it's very interesting, as I think we said at the beginning.
My Lord, we were working through the approach that the tribunal's taken, and it may be that I can take this relatively quickly, because given the exchanges, my position on these points it's unlikely to come as a surprise to the court.
No, but just go through it quickly. Yeah.
We were looking at 14, which is where the CAT's indicating the basis on which it's deciding this point, the CAT rules. It makes the same point in paragraph 19. It refers to the evidence that was before it, that there's an established practice in the tribunal of defendants instructing individual experts in cartel cases. And it says, given that few cartel cases have gone to trial and that there is only really one reasoned decision on the point, which is the point that I've shown this court, the Trucks case, we're of the view that such a practice cannot of itself be determinative. We believe the following matters bear on the approach to be taken, and they identify three matters. The first is the one that we've already been discussing, the power for the tribunal to limit expert evidence. And in doing that, it cross-refers back to Rule 4 and the overriding consideration to ensure the proceedings are dealt with justly and at proportionate cost. It does accept at 19.2, and we say it's right to accept, that if there is a conflict of interest in relation to matters to which the expert evidence is directed, just pausing there, that is a matter which goes to the question of granularity of the conflict. It's not suggesting that there's a conflict simply between opposing parties in itself enough. It's conflict of interest in relation to matters to which the expert evidence is directed. It will not ordinarily be appropriate to order joint experts. In our submission, that is a correct recognition on the part of the CAT.
But you accept, even though there's no respondent notice, that it would be open to us to say that's not the whole story.
I recognise it's open to the court to say that. I would urge the court that the approach should be as indicated in 96 of the previous Court of Appeal judgment. Conflict of interest is a matter which ultimately means it's not appropriate to order joint experts.
So that's why I say it's not the whole story, in the sense that it may be the case, but it may not, is what I'm suggesting to you.
Your Lordship has my submission on that point.
Yes, I think so.
The tribunal says the risk of conflict should be real rather than merely theoretical, and should be first assessed by reference to the claim and defence as they are understood at the time when permission for expert evidence is ordered. And then the third consideration it's taking into account is the case management consideration, where there are three different defendant expert opinions being proposed on the same topic. This necessarily presents additional challenges to the tribunal, which it may be required to reconcile or combine these opinions.
Well, can I ask you about that? You describe that as a case management consideration. Is that right? Is it not a question of the administration of justice?
In my submission, what the tribunal's doing is applying Rule 4 and the requirement that it must deal with.
But that's what I'm wondering about, because case management is about how you manage a case efficiently and cost effectively towards trial. and indeed at trial. But isn't what the tribunal getting at here? It's not case management in that sense. It's not about efficiency and cost effectiveness. It's about how best to achieve a just result, which is why I describe it as administration of justice. That's different, isn't it, to case management, strictly speaking.
If your lordship's suggestion is that it is sufficiently different that it overrides questions of conflict of interest, in my submission it is not so different. It is a discretionary factor that the tribunal is assessing for itself, but in my submission the tribunal was right to recognise that those considerations cannot override.
Well, can I illustrate what I'm trying to get at in this way? And I'm going to put a scenario which I'm not suggesting is this case. It's a caricature. Imagine that you've got two defendants whose desire for pushing forward their own experts is driven by a desire to obfuscate. Because putting up two different experts advancing conflicting methodologies and approaches will throw dust in the eyes of the court or tribunal and thereby obfuscate the court or tribunal's task in determining where justice lies. As I say, that is not this case. It's a deliberate caricature to illustrate the point I'm getting at. That is a more fundamental question than case management, isn't it?
It's certainly a factor that the tribunal has the means of addressing in a variety of ways. It has the ability to give directions as to the way in which expert evidence should be adduced, the extent to which court time can be allocated to it. It can penalise in costs in the event that it considers that the defendants are acting inappropriately. So I don't seek to suggest that that concern is one that the tribunal would not be entitled to take into account. But I do maintain my position that defendants, in relation to which there is a conflict of interest going to the substance of the expert evidence that's being given, are entitled to have their own expert. If they conduct themselves in such a way that that becomes problematic, the tribunal is absolutely entitled to address their conduct in such a way as it considers appropriate.
So your case comes down to this, and this is not to say it's wrong, but just to be clear about it. Your case is the conflict of interest is a trump card. It's as simple as that.
That is my case, and I say I derive support for that from the Court of Appeal in Trust, which is essentially saying that factors such as the duty of independence to the tribunal do not provide an answer to the concerns which arise when an expert is being asked to adjudicate in circumstances where there is a conflict of interest. And I do say that the tribunal rightly accepted this point. It did say, that too, if there is a conflict, it will not ordinarily be appropriate to order joint experts. I say it was right to take that approach. It then goes on, as we'll see, to find reasons why it says that there are no such conflicts. And we say it's made an error of law in saying that there are no such conflicts, but we say that it's absolutely right to take the view that if there are conflicts, that should lead the defendants to be permitted to have their own expert. It is worth spending a very brief amount of time on the reasons why the tribunal has this apparent preference that it would only want to look at one expert report from the defendants. It is under the impression in subparagraph 3 that what it's going to receive is expert opinions being proposed on the same topic, and that it will have issues of reconciling or combining those opinions. if we go on to paragraph 24, which is the second time it expresses this preference, we can see that the defendant's proposal was to look at their own individual data sets. So this wasn't a situation where there would have been duplication, and indeed the tribunal goes on to recognise that there may well be advantages in creating separate models for each of the data sets. That's 6 or 7 lines down in that paragraph. It is, of course, the case that insofar as there are relevant differences of approach between the defendants, or indeed between the defendants and the claimants, then that is a dispute that the tribunal must resolve on the evidence when adjudicating the case. But we do say that that is absolutely commonplace. That is the nature of cases before the tribunal, and so it is not, in my submission, a factor which is so weighty and significant that one will consider it appropriate to prioritise that over considerations of conflict of interest, and of course the tribunal accepts that that's not the case. The tribunal's consideration of the question of conflict of interest itself is in paragraphs 25 to 28. And 25 is the issue of apportionment. The tribunal accepts that it's correct that if questions of apportionment of damages arise, then there may be a conflict of interest between the rival positions of the defendant group. In our submission, it was right to acknowledge that that is the case. It then goes on to say that there is no pleaded issue in the case, and it points to the absence of contribution notices. The court has my submissions on why we say that is misconceived. We say this is an issue which appears on the face of the pleadings because the claimants plead their single undifferentiated claim for damages, and it's simply unavoidable that the question of who pays what out of that total claim will have to be determined. The expert evidence will, and already has, gone into matters that will be of relevance to that issue. And so in our submission, the tribunal was wrong in law to say that there is no conflict of interest arising from the question of apportionment in these proceedings.
Ms. Wall, can I make sure I've not misunderstood something? Because you've said it a number of times and I don't understand why you place emphasis on it, so I better check. When you introduce this topic, you always say that it arises because the claimants have pleaded an undifferentiated claim for damages. But the alternative that they could have done, I suppose, would have been pleaded a difference in what was due from one as opposed to the other, in which that would make your case for you. So I don't understand why it arises because they pleaded an undifferentiated claim. Doesn't it arise despite the fact they pleaded an undifferentiated claim?
My lord, yes and no. The reason I say it arises because I'm addressing the tribunal's position that there is no dispute on the face of the pleading. And they say...
Well, I understand. I mean, your point is, although there's no dispute, although they pleaded an undifferentiated claim, you say there's still a conflict.
I say arises on the face of the pleading.
And it arises from what's pleaded. I get that. I understand that. It's the way you put it, at least the way it landed with me, was it was, as it were, they could have done it differently in a way which didn't raise a conflict of interest. And that isn't your case at all.
Your lordship's right. That's not my case. The
That's all right,
emphasis
that's fine,
comes...
I understand.
It comes from my desire to address the tribunal's preoccupation with the absence of contribution notices and to say that even if there is no contribution in these proceedings, this issue still arises. Paragraph 26 is the pleaded case that was before the tribunal, 2 or more undertakings. Obviously, matters have moved on in relation to that, but the court has my submissions that actually matters have not moved on materially, in the sense that although the claimants have opportunistically chosen now to say that the relevant 2 undertakings that they had in mind were the ones that remain the parties to these proceedings, and therefore there is a allegation of a standalone claim which applies to both of them equally, the reality when one looks at the material that they rely on and the case that they advance against us is that they are still relying heavily on the Commission decisions in relation to which we are differently placed. Paragraph 28 is the umbrella damages claim. And here the tribunal says Commission decisions found distinct cartels related to different defendant groups, it follows that different defendant groups might be responsible for different umbrella effects, whereas we recognise this is a theoretical possibility. Just pausing there, in my submission, what the tribunal is doing there is recognising that there is, in fact, a relevant conflict of interest in that context. It's saying we recognise that it's at least a theoretical possibility that different defendant groups might be responsible for different umbrella effects. What it goes on to do is to make 2 points about what it describes as the theoretical possibility. First, it says it's not one to which the econometric analysis is to be, or for that matter, could be directed. And then it says all that's proposed by the claimants is that there will be a comparison of prices between the clean period and the period during which the cartels, as found by the Commission, were in operation. Now, taking the first point, this is the notion that econometric analysis cannot be directed at questions of causation, and that, in my submission, is excessively simplistic. I showed the court the observations in the DAF case that yes, econometric analysis shows correlation rather than causation, but the whole point of the exercise is for the experts to try and specify their model so that it takes into account the various potential drivers of prices, and so they can investigate the causal questions. And so, in our submission, the tribunal shouldn't be prejudging this issue. The moment the claimants move on from their standalone cartel case, where they rely on their joint and several liability, the moment they're relying on an umbrella damages claim, where the defendants can only ever be liable for the consequences of the infringements that they have been found to have participated in, then it's just not enough for the claimants to show an umbrella effect exists in the abstract. They have to show, the claimants have to show, that the umbrella effect, if there was one, was caused by the infringements to which each individual defendant has been found to be a party. And in our submission, it's no answer to simply say, well, in that case, the claimants will fail at trial, because the defendants are entitled to test and challenge the claimant's case that's being advanced against them. And one way in which they might seek to do that is by means of the expert evidence. That brings us to the second point that the tribunal makes.
Sorry, just make sure I don't want to misunderstand. The point you're making is, for example, there is at least one finding by the Commission of a cartel that involved neither of the 2 parties to this case. That's Takata and Tokai Rikai, seatbelts to Suzuki. And your point is that just showing that there's an umbrella, for all one knows, that was caused by that cartel, and neither of the defendants in this case would be liable for it.
Well, if that were
That's the point you're making.
That is part of the point.
Okay.
But also, each defendant may wish to say, ZF, for example, was only party to OSS2. So it would wish to explore whether or not it could be said that the umbrella damages, any effect that was discovered, was attributable to OSS1 only and didn't apply to OSS2. Conversely, it would be in Autoliv's interest to suggest that an umbrella damages effect was attributable to OSS2, in relation to which both parties would be on the hook, rather than OSS1, where it is the only party that's been found to participate. They have completely diametrically opposed interests in relation to that question. The tribunal's second answer to that is to say, oh, well, the claimants don't propose to engage in that sort of analysis. And unsurprisingly, they don't, because their case is, well, actually, we're just claiming against both of you. But that doesn't mean that we, the defendants, should be shut out from doing it, or at least having the opportunity to investigate that possibility with the expert, if appropriate. So in our submission, we say the tribunal is wrong in law when it makes the conclusion at 29 that there are no material conflicts of interest between the defendant groups in relation to the use of expert evidence. Now, paragraphs 30 and 31 indicated that the tribunal might be prepared to revisit the position if the pleaded case changes, and paragraph 31 says the tribunal may revisit in the light of the claimant's expert evidence once served, and that was the basis on which we made a renewed application to the tribunal, to which I'm about to turn. Just for completeness, paragraph 32 is the final place where you see the tribunal once again reiterating its preference to only receive one expert report from the defendants, and then 34 we see the tribunal rightly recognising that given the size of the claim it's not disproportionate
Can
in
I
terms
just
of
ask
cost.
one last question about what they say in 32? The point, and I think that this is really looking at the way the respondents articulate the same point, which is they say if you have one expert for both sets of defendants, then of course that one expert may look at different data sets, but that one expert will have to be consistent in their methodology. Whereas if you have two experts, then there's a very strong likelihood of inconsistency in methodology. And that takes us back to the point which I think you accepted in response to my very first question this morning, which is it leads to a need on the part of the tribunal to adjudicate not merely between claimant's expert and defendant's expert, but between the rival defendant's experts. So you are multiplying the conflict of evidence even now by 2.
I accept that there may be that possibility. That
And as the Master of Rollers has put you, if you had 6 defendants, it would be even more so.
Well, certainly the possibility must be multiplied in the more defendants you add in. We are, of course, dealing with a situation where there are now only 2 defendants, so that is a relevant factor. But I do resist the suggestion that the tribunal, as a matter of justice, should be avoiding adjudicating these issues, or should not have to adjudicate these sorts of disputes. It is absolutely commonplace, and that's the way in which these cases are resolved before the tribunal, that matters in dispute are tested by way of expert evidence, and then the tribunal comes to a decision on them. It's not axiomatic that the quality of justice will be worse because the tribunal has to hear more evidence and then adjudicate on the differences between them. Entirely possible that the quality of justice may be better by virtue of having the opportunity to hear from different experts. The problem arises where there is a conflict of interest, because in exercising their judgment, the judgment that the expert reaches when they are trying to ensure consistency across multiple defendants may be a different judgment than the one they reach if they're looking at the case in relation to only one defendant. I don't say that it's necessarily wrong, and I'm certainly not suggesting that the expert is advocating on behalf of one defendant or another. But in exercising their many decisions, choices and judgments, they will be put in a different position if there's some imperative to try and come up with a unified approach to everything than they would be if they were acting on behalf of one defendant.
Well, that's a very interesting answer to my question. It leads me to this thought. The justification for having more than one expert, as opposed to a single joint expert, that you find in the White Book, is that where there's likely to be a range of opinion from suitably qualified experts. Now, what you've just said would suggest that you may get a better answer from a multiplicity of experts. And it's false to assume that having just 2 experts will lead to a better answer than 3 or 4. And I see the force of that point. But what I don't understand is why, if the driving consideration is conflict of interest. So, take a different hypothetical to one I was putting to you before, which is your clients adopted the following position, which is to say, never mind whether we have a conflict of interest between ourselves or not. Regardless of that, you might say to the tribunal and to this court, we want to put 2 different experts before the court because we think the CAT would be positively assisted by having 2 different experts giving 2 different opinions on this question. But that's not your case, is it?
Well, my lord, it was the case below, and it was rejected by the tribunal. The tribunal takes the view it would prefer to only receive 1. expert report. We do not necessarily accept that it is correct in that, but we accept that this appeal is based on the question of law as to whether it was wrong to find the absence of a conflict of interest, rather than seeking to second guess the question of whether it is right to prefer, all things being equal, only having to look at one expert report. But I do maintain that problems of conflict of interest are of the nature that they do properly override those more softer case management type preferences.
I wonder if we're beginning to go round in some circles. Had you finished dealing with the decision below?
I was proposing to deal with the second decision.
Yes,
and
that's a good idea.
I'm hoping to finish that by the short journey.
Perfect.
So that is in the updated evidence bundle. I'm probably not calling the right thing. The additional fresh evidence bundle behind tab 21. And just by way of explanation as to how we got to this, the tribunal had indicated that it might be open in its ruling to revisiting. We were very conscious of the imminent deadline for the service of the defendant's expert reports, and so it was felt that if the tribunal were to be prepared to revisit, then it would be a quick means of resolving the matter and it wouldn't be necessary to trouble this court. The material changes of circumstances that we had in mind included the withdrawal of the claim against Dr. Rica, which meant that the tribunal, insofar as it was motivated by a desire only to look at a minimum number of expert reports, would only have to receive 2. We'd also seen the claimant's amended pleaded case, and we'd seen the contents of their expert report by the time of the hearing. So we made very clear in our application that we were not inviting the tribunal to revisit the position in respect of conflicts of interest, because that matter was now squarely before the Court of Appeal. However, the tribunal directed that it wished to hear submissions from the defendants as to why they maintained their position that there was a conflict of interest, and so that is why the ruling, the reasoning in this ruling traverses matters which are also before this court. Our submission is that the tribunal's ruling exhibits the same flaws as its original ruling, but we do say that it brings to the fore what we say are 2 errors in the way in which the tribunal is thinking about things. And the first one goes to the question of the granularity of the question of the conflict of interest that I was canvassing with my Lord Justice Birss. Because the tribunal, in this particular ruling, appears to be taking the position that unless the defendants can come before the tribunal, essentially waive privilege in the ongoing work product of their experts, and provide it with a concrete example of something that the defendants would like their expert to do, but which cannot be done by a joint expert, then it is not persuaded that there is a material conflict of interest. And we see the beginning of that in paragraphs 10 to 13, which is a section of the ruling headed the defendant's evidence. And the tribunal records there, the defendants were asked what it is they intend to show that with their expert evidence. That evidence is to be served on the 24th of May and must be developed to a degree. The defendants were unable to inform the tribunal other than to observe that they were not in a position to prejudge the outcome of any analysis.
So which paragraph was that?
I'm sorry, I'm reading paragraph 10 in the second ruling.
Thank you.
So,
Got it.
in our submission, it is not right that defendant groups should be obliged to come before the tribunal and waive privilege in the ongoing work in progress of their experts in order to persuade the tribunal that there is a relevant conflict of interest. And we've cited in our supplemental submissions a very recent judgment of this court in the McLaren collective proceedings, where another rule proposed by the tribunal had been deprecated by the Court of Appeal on that basis. I can simply given timing, I can simply give the court the reference to that. It's in the Supplemental Authorities Bundle, tab 2, and the relevant reasoning is paragraphs 102 to 108. In our submission, it is an invasion of privilege if the approach to expert evidence goes so far as to require defendants to come before the tribunal and inform the tribunal of the content of their expert evidence in order to substantiate their concerns about conflict of interest. And of course, normally when issues of this sort arise, it will be at an early stage. it's likely to be before substantial progress has been made with expert evidence. And necessarily the tribunal has to reach a view at very much a higher level of abstraction, usually by reference to the pleadings. And so for that reason too, we say it's not right for the tribunal to be indicating a desire to resolve these issues by reference to a detailed scrutiny of the anticipated content of the expert report. Going back to paragraph 10, the tribunal then goes on to say, it says they asked whether during the course of preparation of the evidence specific conflicts between the defendant groups had arisen and none were identified. So what does the tribunal mean when it refers to specific conflicts? In our submission it can't mean conflicts at the level of apportionment or umbrella damages, because those points have absolutely been identified and debated before the tribunal, and the tribunal is well aware of what we say in relation to that and indeed goes on to deal with it in this judgment. So what it means here in our submission is that what the defendants have not done is to identify some specific exercise that they would wish their expert to carry out that it is not possible for a joint expert to do. And we can see that point being made absolutely expressly if we turn on to paragraph 18, second sentence. This is in relation to analysing different periods, which is a matter that we paid before the court this morning. The tribunal says, nor was it explained why a single expert could not be requested to analyse different periods using their preferred model and data sets. In our submission, that is simply the wrong test and the wrong approach, because it should not be necessary to identify a scenario where a joint expert would be paralysed and unable to do anything. The problem arises in our submission when the joint expert is required to make expert assessments and judgments and decisions which are potentially affected by the presence of a conflict of interest. So in our submission, this is an error of approach, and we say it's an error approach which runs throughout the judgment. The second error we identify in this judgment is the notion that econometric evidence is a very blunt and very limited tool, and all it can do is identify an overcharge or the absence of an overcharge, and there's simply no point in exploring whether it can inform any other issues. And again, that's a notion that we see in my submission permeates this judgment, but I'll pick it up in particular when it arises in relation to umbrella damages. Just dealing quickly with the reasoning, paragraph 14 is concerned with apportionment, and it reiterates the point that apportionment doesn't arise on pleadings. The court has my submissions on that as to why we say it does. Paragraph 15 is concerned with table 1.5 of Mr. Hughes' report, which is the one that I showed the court. It's one example where the claimant's expert does traverse matters that are relevant to apportionment. And the tribunal's answer is to say that all he's doing is recording whether sales are made by Autoliv or ZF, and that's a question of fact and not a matter of expert evidence. Questions of values of commerce are, in my submission, questions of expert evidence. The claimant's expert is purporting to deal with it, the defendants need to respond to it, and it's entirely commonplace for economists to grapple with value of commerce issues. Nor in our submission is it a straightforward question of fact. We say that the very fact that Mr. Hughes offers two alternative sets of figures, one based on the claimant's data and one based on the defendant's data, demonstrates that in reaching a view he is exercising a judgment given the state of the available data. And the court also has my submission that one can't assume that the figures are the end of the inquiry. We also need to get into questions of relative responsibility, and the claimant's expert has traversed material that might be relevant to that as well, to which the defendants would wish to respond and in relation to which their interests are fundamentally in conflict. Paragraphs 16 to 18 are where the tribunal deals with the fact that ZF was a party to OSS 2 but not OSS 1. Paragraph 17a is making the point that the expert evidence is not capable of informing the tribunal as to whether the overcharge is arising from cartelist activity involving ZF, an Autoliv, or an umbrella effect. And it's certainly the case, and it's an oddity in our submission of the claimant's expert approach, that they haven't sought to provide separate analyses for their standalone cartel case and their umbrella case. They just provide an overall figure for cartel for alleged overcharge, which they say arises irrespective of which case you're looking at. And our submission will be that they take that approach at their own risk, because if they don't manage to show a standalone cartel claim, then they cannot assume that the defendants are jointly and severally liable for an overcharge that only arises by way of umbrella damages. Paragraph 17b is a paragraph where they say that it's not suggested by ZF that they intend to argue that any overcharge for the period prior to their participation in OSS2 is caused by an umbrella effect arising from OSS1. Now, it's true, we have not sought to say specifically that any overcharge in the period that we didn't participate must have been caused by OSS1. But ZF is not obliged to advance a positive case about what caused the overcharge. We are entitled to say that the burden is on the claimant to show that any overcharge in this period is attributable to conduct for which ZF is liable, and if all the claimants have is an umbrella claim, then clearly it's not been found to infringe in the relevant period. And the court has my point that the issue doesn't stop there. The tribunal's reasoning stops there, but the importance of this period of time where only one of the infringements is operating is that it might well enable the experts to interrogate whether or not one can distinguish between the cause OSS1 or OSS2, which, if either, were actually causing any overcharge effect. 17c is the part where the tribunal reiterates that all expert evidence can do is to identify the existence of an overcharge. It is a blunt tool that is not capable of distinguishing the causes of that overcharge. The court has my point. We do not accept that expert evidence is necessarily so limited, and in our submission the tribunal shouldn't be prejudging this point in circumstances in which the defendants would at the very least want to explore with their expert what potentially might be capable of being done to separate out these effects. Paragraph 18 in our submission is quite telling. First says it was suggested that there may be a benefit to ZF in having different periods analysed. It was not really explained which periods or for what purpose. The answer to that is the periods over which the defendant's participations in the infringements differ, and the purpose is to try and interrogate whether the claimants have discharged their burden to show a causal relationship between umbrella damages and different infringements. And I've already shown the court this second half of 18, nor was it explained why a single expert could not be requested to analyse different periods using their preferred model and data sets. In our submission, it's not right to apply a test that requires us to find something that cannot physically be done by a joint expert. The question is whether or not it's appropriate for the joint expert to do the exercise in circumstances where their exercise of judgment will be potentially impacted by the existence of a conflict of interest. We then have the further point about the benefits of a single expert, which we've debated at some length already. It's paragraph 19. And finally, paragraph 20, it said that the complaints that the defendant's interests may be different appear at most abstract and theoretical and do not impact on the nature of the expert evidence which is to be adduced. Again, in our submission, this paragraph absolutely encapsulates the error, because the differences in the defendant's interests are far from abstract and theoretical. They are absolutely manifest. What the tribunal really means is that we have not identified a specific exercise which we would like our expert to do, which a single expert flatly could not do. And in our submission, that is simply not the right test. So, in our submission, the tribunal's latest ruling is wrong in law for the same reasons as its earlier ruling. My lords, unless I can desist further, those are my submissions.
Thank you very much indeed. Brilliantly timed, Miss Ford, if I may say so. We will adjourn now and start with Mr. West at 2 o'clock. Thank you.